Yes, thank you for joining me. And we are talking about President Donald Trump's executive order number 14156 on the bare right citizenship in the United States and eviscerations of the 14th Amendment to the Constitution of the United States. We are responding to the question, does it impeach or sustain state and congressional autonomy? History has it that on June 16, 1866, the U.S. Congress has a joint resolution to propose the 14th Amendment to the Constitutions of the United States, and same was submitted to the state, which led to the declarations of the 14th Amendment in a certificate of the Secretary of State, and the ratification by the necessary 28 out of the then 37 states of the United States to become part of the supreme law of the United States. That is the laws of the United States of America. In fact, Congressman John Hay Bingham of Ohio State, who was the primary author of the Section 1 of the 14th Amendment, that is Article 14 of the U.S. Constitution, intended that the amendment also nationalized the Bill of Rights by making it binding on states. You will agree with me that every law is interpreted based on intent of the drafters of the law. So a straight, or when I say analytical look at Section 1 of the 14th Amendment to the Constitution of the United States indicates that there is no requirement of nationality of the United States, whether particular interests are at stake, that requests or requires executive arms of government or the president to make an additional declaration to issue interpretation or determination whether or not the person is of the U.S. nationality or citizenship, when it flows or is derivable directly from birth that takes place on the United States soil. Let's look at Section 1 of the 14th Amendment to the U.S. Constitution. What does it say? If we may rephrase it in our mind, all persons born or naturalized in the United States and subject to the jurisdiction thereof. Please take note, because this will be a key word, subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of law. That is the terms and the wordings of Section 1 of the 14th Amendment to the United States Constitution. From that, it is my view that Section 1 of the 14th Amendment of the U.S. Constitution contains two sets of powers and two sets of limitations. The first limitation on power under Section 1 of the 14th Amendment of the U.S. Constitution is that all persons born in the U.S. soil are citizens, except where the person was born under the jurisdiction of another country based in the U.S. soil. So let's look at the meaning of the U.S. jurisdiction under the law. Under the provisions of the Vienna Convention on the Diplomatic Relations, in 1961, which is an international treaty that establishes the rules and guidelines for diplomatic relations between independent countries, jurisdictions of countries within the land of a country, limited by within the land of a country. It is under this law that limits three key legal principles limit the issue or the terms of jurisdiction and define it. The principles are sovereign immunity, diplomatic agents missions, diplomatic agents and missions are immune from jurisdiction of host country. That is to say, a person in an embassy of a country in the United States, or born in an embassy of the United States, or reside in an embassy of a country in the United States, of any other country in the United States, is not subject to the jurisdiction of the United States. An embassy or office, a mission or a foreign office of a country in another country is not within the jurisdiction of that country. The second key principle is inviolability under the Vienna Convention on Diplomatic Relations. Diplomatic missions and agents and their residencies are inviolable and protected from any intrusion or damage. That is the international law on diplomatic relations. The third one is diplomatic privilege. Diplomatic agents and their family members, their wives, their kids enjoy privileges such as tax exemption and immunity from civil and administrative jurisdiction. It is therefore the Vienna Convention on the Diplomatic Relations, which is the extant law that provides a framework for diplomatic relations and operation between states, and that limits the terms of jurisdiction. In this case, in the United States, the jurisdiction of foreign missions or international diplomatic organizations, such as, and their subjects, such as children of diplomatic agents, of diplomatic missions, of plenipotentiaries, ambassadors, or other ambassadorial persons, are not citizens of the United States, because they are not subject of the United States jurisdiction, even though they are born in the United States soil. For example, a child born in the office or the headquarters of the United Nations office is not subject of the United States. Is not a subject of United jurisdiction of the United States. Or born in the embassy of China in the United States is not a subject of the United States. That is that word. Subject to the jurisdiction thereof. The one is born in the United States soil, not in any diplomatic mission, is a subject of the United States. So every law is to be determined by the intent of the legislature. The conscious use of the word all persons and subject to of the jurisdiction thereof by the drafters of the Constitution of the United States demonstrate beyond any doubt that only children born at the offices or residences of diplomatic missions are not subject of the jurisdiction of the United States. But when born in the United States soil, outside diplomatic missions, offices or residencies, they are subject of the jurisdiction of the United States and therefore citizens of the United States. The second limitation is that no state is permitted to abridge the citizen status or rights created by the Section 1 of the 14th Amendment, nor to deny any person within its jurisdiction the equal protection of the laws. Section 1 of the 14th Amendment is therefore an inviolable provision and gives no power to the President of the United States, nor any state that breaches its provision or makes its interpretation by executive order or fiat. The power bestowed by the 14th Amendment is the power of enforcement bestowed on Congress. 14th Amendment does not power to the U.S. Congress. See Section 5 of the 14th Amendment of the United States Constitution, which provides that the Congress shall have power to enforce by appropriate legislation the provisions of this article. The Congress shall have power to enforce by appropriate legislation the provision of this article. Power is therefore donated to the states to ensure equal protection of all persons and equal right by law, and further donated to Congress to enforce the article 14 by appropriate legislation, that is to say, by an act of Parliament. It is clear that the President of the United States cannot expand or interpret or abridge or do anything otherwise with the terms and the provisions of the 14th Amendment without the power conferred upon him by Congress and by way of legislation and ratified by states. Due consideration to the obligation of all states to ensure equal protection of all persons or rights by law. It is therefore my submission that the execution and implementation of such an executive order number 14156 issued by President Trump is an aberration to the Constitution, Section 14 of the Constitution of the 14th Amendment of the Constitution of the United States. The executive order on childbirth issued by President Trump is an impeachment of Section 1 and Section 5 of the 14th Amendment of the Constitution of the United States, and therefore an aberration to the intent and purpose of the U.S. Constitution. It is of course, a direct affront on the cultural sensibilities of states and powers of the U.S. Congress. Nothing can be done by a president except where Congress, as to the power of enforcement under Section 5, Sub 5 of the 14th Amendment, donates such power to the president by way of legislation, which same must take into consideration the duty of the state to ensure equal rights and protection of persons by states. Under the U.S. Constitution, the president cannot act on 14th Amendment without the U.S. states and the U.S. Congress. He does not have that power. So I see the President's Trump effort on the 14th Amendment as nothing more or less than an attempt to cause the U.S. Supreme Court to redefine the 14th Amendment away from what the U.S. Supreme Court has already defined in the United States vs. Wong Kim Act of 1898. Citation will be provided in the transcription of this lecture. So, by way of executive order to instigate lawsuit to the Supreme Court to change the provisions of the U.S. 14th Amendment by way of interpretation, same way that the Supreme Court changed the decision in Roe vs. Wade of 1973. That's the strategy. So, under the U.S. Constitution, if the Supreme Court will want to go by law, the president will be told that he does not have that power. Under the law, it's only Congress can donate power to him by way of legislation. And that way of legislation must take into consideration the duty of the state, of each state of the United States, the 50 states of the United States, to protect the equal right of person. That is to say, the state must ratify such legislation before it can stand. So the Congress does not even have a singular or exclusive power. It must be subject to that duty of the state, because the state can oppose the Congress. But under Section 5 of the Constitution, Section 5 of the 14th Amendment, the power of the Congress may be opposed by the state, who says, no, they have the right to protect this and that. It's the duty of the state to protect. So you have to take into consideration if this is what we want as states. So under the U.S. Constitution, to amend the 14th Amendment of the U.S. Constitution, it would require 2/3 of the states of the U.S., of the entire United States, to ratify an act of Congress for its amendment before the president can assent. That is where the power of the president comes in, to assent to the amendment of a bill for an act of the Congress. So the president cannot act by way of executive order under the 14th Amendment to the U.S. Constitution without consulting and receiving joint blessing of the state and the U.S. Congress. Doing so constitutes a gross violation of the United States Constitution. So the answer has been given to you that it impeaches the autonomy of states and of United States Congress. And I think the President Donald Trump's legal advisors on these constitutional lawyers need to read and analyze, read more again, analyze their brain, and maybe subject themselves back to law school and university to be able to already advise the President Trump very well. Otherwise, it becomes a subject of mockery. They have subjected the President to mockery, making people look at the President as he does not know anything. And that's so bad. Thank you. I hope you got the answer, which a lot of people look up to, from my view. Thank you, and God bless you.